when you're making a presentation, when you're talking to a client or to a senior partner, or really to anybody, be aware of the fact that they're doing research about attention, where they're actually doing some far out stuff with MRI imaging and stuff. They're finding out that we all have about a 10-minute attention span of really focusing to the brain kind of wanders. And so you need to kind of, that's why I want to have next week a 5-minute drill. This may be the most valuable thing you get out of law school, is to train yourself to make a presentation on whatever topic within a particular time frame. You ever get up to the appellate court, they have little clocks, little alarm goes off, beep, red lights flash, and you'd better stop talking, because if they don't, then like for instance the 11th Circuit, they will tell you, please counselor, your time is up, etc., etc. So it's important to learn how to say something that you want to say within a particular defined period. And you need to do this, it doesn't just happen automatically. You need to get the stopwatch feature on your phone or look at your watch or something and practice it and time it. And also, by forcing yourself to make a verbal presentation on a topic, you're going to force yourself to think it through and really find out what is really important. What am I really doing? What's this paper really about? And so that's why they say a good way to learn something is to teach it to somebody else. Perhaps if you're a little suspicious, you might think that's why Professor Hamilton and I teach it. Of course, it's not true for us, but it is true. And when you go back and people find out you've done e-discovery in your firms, in your practice, and wherever you end up, you're inevitably going to be called upon to be teaching somebody something down the road. I'm already seeing it happening from the students that we've had already. So you're going to have to, learn how to make these presentations and realize that there's only a limited attention span. Does that mean, and by the way, most politicians today get this, so speeches are shorter and shorter. The old days of Civil War, you'd read stories about how they'd have a speech that go on like two hours and stuff like that. Lincoln's Gettysburg Address was a genius because it was short and it really took advantage of that ability. It doesn't mean that your opening statements are only going to be 10 minutes to be effective. That's not what I'm saying. What it means is after 10 minutes, you better do a and let them break. And the really polished trial lawyers, they get this instinctively. They haven't read the studies, but they're not going to go on and bore their audience or their jury or their judge. They're going to have some kind of break in between it, and it's kind of 10-minute intervals. What's new is apparently this realization that 10 minutes is key. If you want to see a master at work, go to YouTube and look at Steve Jobs in any of his big presentations. He knows the 10-minute rule. They consciously design everything for 10 minutes. And then after 10 minutes, he'll switch. He'll do a demo. He'll do something like I'm going to do right now. Here's my new book. So pass it around if you would, please. Break it up a little bit. He actually passed around the case when he was demoing the new Mac notebooks. He passed around the metal case and handed it out. He'll bring in somebody else to talk. He'll change the subject, or good trial lawyers have a million stories. Abraham Lincoln was known for his funny stories. That's why he was so effective as an advocate, is he would break, and you need to learn how to do that. So that's one of the reasons I want you to learn on the 5-minute process. Yeah.